967 days. That's how long I waited to hear a sentence for the man who killed my daughter. 4.5 years and a 7-year driving ban. That's what her life was worth in a Canadian courtroom. I watched him get handcuffed. I watched him be led away. And everyone asked me the same question. Do you feel better now? I didn't. So what is justice when the person you love doesn't come back? Every year, thousands of Canadians are injured or killed because someone chose to drive impaired. Behind each number is a name, a story, a family forever changed because someone chose to do something we all know to be dangerous, reckless, illegal, and frankly stupid. When you lose someone to impaired driving, you are deeply heartbroken and righteously angry, furious that their death was senseless and preventable. Why? Why do people still do this? Why are Canadian lives still being stolen? Are we really okay with this? Why do we continue to tolerate it? What will make this change? I'm your host, Amanda Bickell, and this is LIVID, Learning, Insights, and Voices on Impaired Driving. This podcast is about real stories, hard truths, and how through learning and honest conversation, we can move from anger to action and work toward a Canada free from impaired driving. It's time to be livid. LIVID discusses impaired driving, traumatic loss, grief, and the justice system. Some content may be emotionally difficult, especially for those personally impacted by these issues, and so listener discretion is advised. The views shared on this podcast are personal and educational in nature and are not legal, medical, or professional advice. Where legal cases are discussed, details are shared responsibly and based on publicly available information or personal experience, and nothing shared here is intended to prejudice ongoing proceedings. Our goal is awareness, understanding, and change. On March 12, 2026, Abby's killer was sentenced to 4.5 years in prison. I attended court. I watched him being handcuffed and taken away to prison. 4.5 years. Abby's life was taken 967 days before. For 967 days, I've been waiting to see justice done. And there it was. It was over. Why didn't I feel better? As soon as I left the courtroom, people started asking me, so how do you feel? What do you think? I didn't know. I know what people expected, something about closure or maybe outrage that the sentence wasn't enough. I felt no closure. If anything, I felt sad because as long as the court process was ongoing, Abby's story wasn't over. There were real, practical things that I was doing in my life that were for her. And with court over, this chapter was over and Abby felt really gone. So I didn't have room in my head or my heart to draw conclusions about how it ended. I wasn't outraged, but only because I had prepared for worse. So many cases come to a different close with no accountability at all or a really light sentence. I had been preparing to have that disappointment all the way along. But it had happened. Her killer was going to jail. But how did I feel about that? At the time, I focused on the positive. I tend to do that in the moment when I'm put on the spot. It is safest. It offends the least number of people. It takes me time to process things, to really understand how I feel about them. I'm just that kind of person. Even in the normal course of day-to-day, I want agendas before meetings. I feel like big reports should be sent ahead of time because I need to read and think critically before I chime in. This had been a lot of information, a lot of emotionally charged information, and I had just received it. I hadn't had time to process it all, and I was busy being surprised at how tired and overwhelmingly sad I was feeling. But I knew the question would be coming, so I had prepared what I might say in the moment based upon different possible outcomes. I knew I couldn't comment on something as grave and complex as the sentencing decision in the immediate moments after I had heard it. I needed time to reflect. So when I was asked about the decision by CTV News on the courthouse steps, I said what I could say honestly, that procedural justice had had a good outcome, but that restorative justice is impossible. But how do I feel about it? It's been a couple of weeks since the decision was made. Some parts of it make sense. Some of it is infuriatingly unfair, and some of it, well, most of it, is still keeping me up at night. What is clear is what led to the 4.5-year sentence. I can explain that. The process took 3 visits to court and weeks of consideration by the judge, so to unpack it all for you will take a bit. So in this episode, I'll share the arguments of the Crown. These included the sentencing principles, the aggravating factors of the case, and some mitigating factors, as well as an analysis that was refreshingly frank and to the point. In the next episode, we'll look at the mitigating factors as presented by defense counsel, the judge's decision, and the problems with the outcome. The what happened and what they said does give insight into how the sentence was determined. But whether it is right, was justice served? Is this a good outcome? Well, all of that is a lot more complicated. So let's tease it out the way it unfolded in court. After the victim impact statements were delivered, which I talked about in episode 2, it was the Crown Counsel's turn to speak. I am no expert, but as a university educator, I have seen a lot of presentations, considered many, many intellectual arguments, and so I feel like I have a sense when somebody knows what they're talking about. The Crown Counsel assigned to this case was thoroughly prepared and presented a clear and logical argument. All of the points were supported with relevant precedent case law, all phrased as if he had done the work to assist the court, to inform its decision, not to dictate it. His work really made it easy for me to understand the expectations and the confines of the legal system around sentencing for this case, and that has made it possible for me to see some small degree of peace with the outcome. I don't have to like it to understand it, but understanding has really helped me be okay in some ways at least. The argument considered the illegal behavior for which the sentence was to be decided, the principles of sentencing that direct the court's sentencing decisions in all such cases, the factors of the case that mitigate the situation, and those that aggravate it. First, he outlined the what. As we consider the sentence and whether it fits, we have to be clear on what happened and what the charges were. We talk rather loosely outside of court, but it is important that when other situations are considered or compared to this one, that we know what the official charges were. In this case, the offender pleaded guilty to operating a conveyance with a blood alcohol concentration above 80 milligrams per 100 milligrams of blood. This is commonly referred to as driving over 80, causing the death of Abby, and then another count for causing the bodily harm to her friend Scott. He also pleaded guilty to the charge that on the same day he failed to stop, what you often hear described as fail to remain, after a collision which related to the first minor crash he'd caused before colliding with Abby and Scott. Sentencing principles were the next factor presented. This was completely new to me, so after court I had to look it up. Section 718 of the Criminal Code of Canada deals with sentencing in Canada and is called, quote, Purpose and Principles of Sentencing. It serves as the sentencing rulebook, if you will. Basically, the reasons that courts give sentences are to protect society and to signal to the members of society that you have to respect the law. In doing so, it is expected that people will follow the laws of the land and we can all live free from criminality in peace and comfort and safety. Yeah, that is my cynicism sneaking through already. Anyway, back to the rules. Sentences are to protect society and signal respect for the law. Any sentence imposed has to be just and is expected to deliver on one or more of the 6 objectives, which are denunciation. Publicly say that what was done was bad and society won't tolerate it. 2, deterrence. Prevent it from happening again. 3, separation from society. You can't play if you don't play nicely. 4, rehabilitation. Correct whatever it was that led to the criminal behavior. 5, reparation. Make amends, make up for your bad behavior. And 6, responsibility. Offenders need to take responsibility and acknowledge the harm done. I feel it's important to share that I was surprised that punishment is not a principle of sentencing in Canada. Punishment is discussed in the criminal code, but it is not a principle of sentencing. I will admit I was shocked and offended by this when I first came across it, because when Abby died, my thoughts were that someone should pay for this. Someone should suffer for this. Someone should be punished for this. The legal world considers denunciation and deterrence to relate to punishment. But from my perspective, they are not the same thing. In my anger, my hurt, those eye for an eye thoughts and feelings certainly didn't think they were the same. In my more rational humanist moments, I realized that nothing that happens to this offender will bring Abby back, and that cruelty and violence would not honor her. She was better than that. But nothing happening to him doesn't feel right either. And then I was stuck. I've been mulling this one over for a long time. What is justice in this case? What does a just consequence look like when someone kills someone? I haven't gotten to a sound position on it yet. And since legal philosophy is a complex topic and not my specialty, and not one I've had the patience for thus far, I'm going to have to defer that conversation. I need an expert. If you know one, I'd love to talk to them. But for now, all I can say is that I'm not settled on how I feel about this. However, that a punishment is not a sentencing principle in Canada will come back to explain a lot about this decision and how I feel about it. In this case, the two primary principles for these three offenses, over 80 causing death, over 80 causing bodily harm, and failing to remain, are all the same. They are denunciation and deterrence. So the primary objectives of the sentence is to say that what was done was bad and society won't tolerate it, and to discourage it from being done again. Crown also quoted section 320.12, the aspect of the criminal code that deals specifically with operating a conveyance. I include this here because in my discussions with others, I have often heard people declare that they believe that driving is a right, protected under Canada's Charter of Rights and Freedoms. It is not. Section 320.12 reads, "It is recognized and declared that A. Operating a conveyance is a privilege that is subject to certain limits in the interests of public safety that include licensing, the observance of rules, and sobriety. B. The protection of society is well served by deterring persons from operating conveyances dangerously or while their ability to operate them is impaired by alcohol or a drug, because that conduct poses a threat to the life, health, and safety of Canadians. Driving is a privilege. We earn it by demonstrating that we have sufficient skill to operate a vehicle safely and know the rules of driving. We have to show that we are able and willing to adhere to them. This is reinforced with licensing processes and insurance contracts. As a driver, you assume responsibilities that many of us take for granted, but that doesn't change the real gravity of those responsibilities. Failing to respect them leads to so many negative consequences, and in order for all of us to be safe, all drivers must be responsible. As I heard this in court, I felt just how ominous the juxtaposition of that really is in my experiences with Abby's death, but also just in my everyday experiences on the road. Driving is one of the most dangerous things that we do on a daily basis. Some would argue the most dangerous. The burden of that responsibility is underestimated, overlooked, and in general is taken far too lightly. It is for that reason that the Crown Counsel raised the issue in court. Our society depends on the relative reliability of most drivers. When one demonstrates themselves to be unworthy of the privilege, the safety of others becomes the priority. These first things outline the objectives and priorities that apply in all cases of impaired driving, not just this case. But every case is a special case. Each is unique. The Supreme Court of Canada specifically spoke to the broad spectrum of offenders and circumstances in impaired driving cases in the 2018 Regina versus Suter case, and for that reason, the specifics of each case must be considered in deciding on a sentence. This is why automatic minimum sentences are not in place for impaired driving. Despite the same law being broken, it matters how it was broken, who broke it, and what was going on with them at the time they broke it. It even matters what they did after they committed the offense, both in the immediate aftermath and what they have been doing in the time the court has taken to arrive at the sentencing decision moment. It also matters who was killed, who was injured, the nature of the injuries, and so on. This is what victim impact statements are for, to help the court understand the harm caused. This is another area where I am torn, and I don't know how to feel. Should it matter why or how someone ended up killing another person while driving impaired? The consequences are the same. Abby isn't any less dead, no matter what circumstances are considered. Should it matter that Abby was loved deeply, that she was a good person that is terribly missed? If someone else had been killed, perhaps one of the poor souls who live on the streets this driver sped through, someone addicted and suffering, if he'd hit one of them instead of Abby, should it matter to the court? He would have still killed someone. Aren't all lives equally valuable to the court? Sadly, clearly not. This doesn't sit well with me. So the Crown started outlining the key things about the case that the judge needed to know to have sufficient context to create a unique sentence for this special particular case. Some of those specifics make the situation worse. They make the offense more severe or the offender more morally culpable. Anything that increases blameworthiness or the dangerousness of the behavior, any of these things are known as aggravating factors, and they are the ones that end up leading to a harsher sentence. Crown Counsel presented statutorily aggravating factors first. These are circumstances that have been specifically outlined in law as being aggravating. They are legally defined circumstances listed in criminal statutes. If they are present in a case, they can require or at least allow a judge to impose a harsher sentence for a crime. In this case, there were three. First was the blood alcohol level. The law broken in this case was driving over 80, but the offender was well over the 80 milligrams of alcohol per 100 milliliters of blood. It's on the books that if a driver has a blood alcohol concentration exceeding 120 milligrams of alcohol per 100 milliliters of blood, it is an aggravated amount. But Abby's killer's blood alcohol level was twice this aggravated amount. The second one surprised me. I didn't know that the size of your vehicle matters, but it does, and it makes sense. The physics are obvious. A little hatchback isn't capable of doing the same amount of damage as an oversized pickup. The statute doesn't specify what constitutes a large motor vehicle, but the case law does, and a 2022 case determined that an SUV constitutes large. The Chevy Silverado that the offender was driving when he killed Abby is as large or larger than the SUV in the case law. The third one is about impact on victims. It is statutorily aggravating in any driving offense that causes a death. Crown Counsel then continued with highly aggravating factors. These are things that are making things more serious, the actions more blameworthy, and the offender more morally culpable, but are not included in statute. They were supported by case law, which means that in other cases, other judges have noted in sentencing decisions that these factors aggravated the situation. In this case, there were three highly aggravating factors. Blood alcohol came up here again. Because the blood sample wasn't taken immediately at the scene, but was taken in hospital an hour after the crash, the 241 milligrams per 100 milliliter result was lower than what his blood alcohol would have been at the time of the crash. Crown Counsel described this as an extraordinarily high blood alcohol concentration. Second was the extremely dangerous driving. Crown Counsel noted that even if the offender had been stone cold sober, the way he was driving, excessively speeding, running red lights, crossing the middle yellow line, all would have made him liable for dangerous driving causing death and bodily harm. The Government of British Columbia Motor Vehicle Act specifically defines excessive speeding. Anything beyond 40 kilometers per hour above the limit is legally excessive for speeding. For 6 blocks, this offender was driving nearly 100 kilometers an hour over the speed limit, and then when the speed limit increased, continued to drive at least 60 kilometers beyond the speed limit. Then there were the 6 red lights that were violated, the final one being the fatal one. The third highly aggravating factor was that his extraordinary speed and total disregard for traffic signals were because he was fleeing the scene of the first collision he'd caused, the minor one, for which he was attempting to avoid responsibility. Yes, this is a separate offense and one he also pled guilty to, but here it was presented as also being aggravating. This was another thing that made sense to me. Some of my earliest thoughts were that if only he'd stopped, none of this would have happened. No one had been hurt at that point. To me, not only was this highly aggravating, but it was pivotal. To me, deciding to flee demonstrated cowardice and selfishness, and it was those that had him driving so dangerously, and that speed is what killed Abby. To hear this included here was important to me. The offender's driving record was the final aggravating factor presented. Although Crown Counsel presented it as not highly aggravating, it was a big enough problem to include it. The offender began driving in 2009. He has 9 speeding tickets, 1 for excessive speeding. He also has 2 tickets for driving without consideration for others and 1 for running a stop sign. He lost his license twice in the time between 2011 and 2012. He has 5 non-moving violations. I don't know what they are. I don't think it matters, but they demonstrate continued disrespect for the laws and responsibilities of driving. His most recent court appearance was in June of 2023 for a driving without insurance ticket from 2022. It says something to me that he was in court fighting something like that just weeks before he killed Abby. However, Crown Counsel suggested that since most of this behavior had happened in the first years of his driving career, from 2009 to 2017, it wasn't as aggravating. I don't know. I've been driving for 36 years. I don't have any tickets. On the other end of the spectrum are specifics and circumstances that may reduce an offender's culpability and serve to reduce the sentence imposed. All of the definitions I could find talk about how these are not things that justify or excuse a crime. They just somehow make it less bad or make the offender less blameworthy somehow. I really struggled with all of the mitigating factors that were presented in court. They all sound like shirking responsibility to me. So as I present them, know that I think all of these sound like excuses and a failure to have the courage to take accountability for choices, decisions, and actions that entirely are those of the offender. I can't sanitize this to present them objectively. I guess this is full disclosure on my bias. Anyway, in court, Crown Counsel had the submission from defense in advance and so spoke to each item in his remarks. Then defense counsel presented the perspective of the defense on each one, although curiously didn't dwell on the ones that Crown had already argued so well. I'm going to just go through each one once. First, let's look at the mitigating factors that Crown essentially shut down in his arguments, so much so that defense chose not to elaborate upon them orally in the hearing. First was the crippling effects of jail time. This argument was essentially that going to jail for 5 years, which was the sentence recommended by Crown, would ruin the offender's life. They talked about how he was a young man, only 31 years old, with his whole life ahead of him, and how jail time would ruin his future. So that got me thinking about what he had done with his 31 years up to the point of the crash. From what was reported in court, at that time, he was an unemployed former oil patch and construction worker who had an undiagnosed alcohol use disorder and a penchant for illegal driving and a lack of respect for the laws of the road. There was no mention of a partner or dependents or a business or property or anything that he was responsible for. He may very well have these things in his life, but they didn't come up in court. Personally, I don't think 31 is young, and I resented him being spoken of as if he were just out of childhood. I couldn't help but compare him to his victims, to Abby and to Scott, both nearly a decade his junior, and both with the productive and independent lives they had already built for themselves. Gratefully, the Crown pointed out the glaring disconnect between this logic and that of the consequences of the crime. Abby had her whole life ahead of her. Abby's life was ended because of his actions. A 5-year prison sentence doesn't end his life. If anything, it could be the opportunity to make meaningful change for the better. The next bit for this one was that going to jail for this long would make a career criminal of him, that he would be turned bad by his prison experience. I would argue that this is a choice. Sure, I imagine that you could meet some pretty interesting people in jail, but deciding what you will do when you get out of prison is entirely your own decision. So with this argument, in my opinion, he is admitting that he is a lemming and is incapable of making his own decisions or standing up for his own values and doing what is right. If that is the case, the danger to the public is keeping him out of prison, because in doing so, he remains in the very environment that forced him to conform by behaving in this dangerous and deadly manner in the first place. Next, what about his dog? Yeah, his dog. The inability to care for his dog was raised by defense as a collateral consequence of a prison sentence that should support reducing that sentence. I'm serious. So were they. He killed her. And defense counsel was arguing that he shouldn't go to jail because he has a dog. Now, I'm a dog lover. I have 3, actually. Abby was a dog lover, too. I feel for the dog. But surely someone in his community can care for the dog in his absence. Again, I really admired how Crown Counsel addressed this one. He found a case that involved a single mother of 3 children, all of whom depended on her as she was their primary caregiver. Additionally, 2 of the children were disabled, and the medical coverage from her employment supported their care. Clearly, jail time would have significant negative consequences for these 3 children. And yet, in that case, she was still given a 4-year jail sentence, along with a DNA order and an 8-year driving prohibition. The case law that followed fascinated me, but it was repetitive and somewhat tedious. Crown presented 6 different cases with similar circumstances. For each one, he meticulously noted the similarities and differences between those cases and this one, each comparison demonstrating why the 5 years in jail and the 8-year driving prohibition was an appropriate sentence. And then he concluded his arguments. Here he emphasized the 4 most important conclusions for the court's consideration in sentencing. First was the extremely high moral blameworthiness of the offender. So much contributed to this. He was driving dangerously while heavily intoxicated at over 3 times the legal limit, all because he was fleeing the first crash in an attempt to avoid the consequences. He ended up making things so much worse for himself and others. The Crown Counsel used an analogy here. He said the offender was like a robber who kills a witness for seeing their face. He committed a much bigger crime to avoid being caught for the smaller one. The end result was death and destruction. The speed and disrespect for traffic rules made this outcome inevitable. Next, being heavily intoxicated doesn't reduce moral culpability. One of the things that the defense of an impaired person can include, as it did in the case of this offender, is the notion that decision-making was affected by the intoxication and therefore should reduce moral culpability. Crown spoke directly against this. Yes, the effects of alcohol can disinhibit a person and contribute to poor choices. But rather than an excuse, Crown argued that the intoxication was aggravating. And had the offender done all of this sober, the dangerous driving, the fleeing the scene, it would have actually been less aggravating. One of my favorite quotes from this section went, and I quote, "The court should avoid the analytical pitfall of thinking the offender's moral blameworthiness should be reduced due to his very high intoxication. Such reasoning would be perverse and contrary to the law." Unquote. Next was the offender's behavior. The offender's behavior is not without explanation. The defense had reported that the reasons for the offender's behavior cannot be known because he has no memory of the events of that morning and no insights as to why he would have done what he clearly did. But from what he did, we can know that despite being heavily intoxicated, he prioritized leaving downtown Vancouver to get home to his residence in the suburbs and chose the most convenient way to do so. to drive himself, despite knowing he'd been drinking. I feel like suggesting that if you don't know how much you've had to drink, a reasonable person would take that as a sign that whatever the amount, it was too much to drive safely. But at this point, it didn't appear that Crown needed my help, so I didn't chime in. The offender also chose to drive dangerously to avoid getting caught for the initial collision. Crown proposed that these are not inexplicable choices. And then he added another of my favorite quotes from the day. Quote, "They are horrible choices of a person putting their own convenience and self-interest ahead of the law and public safety and killing someone as a result." End quote. Crown Counsel didn't leave it there. He reminded the court that there are plenty of licensed drivers who have drinking habits and diagnosed or diagnosable addictions to alcohol who do not drive while intoxicated. That this offender chose otherwise is not inexplicable. He said the offender's decision arose from his own personality factors, beliefs, and habits, and just because the investigation didn't uncover the precise details of those, so the court cannot know them, it doesn't mean the moral blameworthiness should be reduced. The offender's actions are clear. The consequences are clear. That he can't explain them doesn't reduce his moral blameworthiness. The final argument talked about Scott. The survivor suffered more than bodily harm. Here the court heard about Scott's physical injuries. They were awful, but gratefully he has recovered from those. What will never leave him are the memories of that awful day. To conclude, Crown Counsel chose to refer to Scott's statement to police. It showed what Scott remembers. He remembers the moments before the crash, when he heard Abby's last word, her yelling his name, and the minutes after. What I'm about to say next is brutal and graphic, so here is a minute for you to skip ahead to the next chapter. I promise you will only miss a little bit. Scott told police that after the collision, he was conscious in his vehicle and saw Abby's corpse, the body of his deceased friend, which had been pushed into him due to the force of the collision. In fact, many of his injuries are the result of that force having been borne first by Abby, and then what remained transferred to him as her body collided with his. He told police that her neck didn't really look proper. It took 5 minutes for Abby to be extricated from the vehicle, and another 15 minutes before Scott was removed from it. With Crown Counsel's points made, the floor was given to the defense counsel. In the next episode, I'll tell you what he had to say. This was by far the most infuriating part of the sentencing hearing for me, and I expect you'll have a similar reaction. So be prepared to be livid. I'll also tell you what the judge made of all of this, explain the decision, and tell you what I'm thinking about the justice of it all, or lack thereof. Thanks for listening. This episode was written and produced by Amanda Bickell. Music by Emily Gordon. All rights reserved. I want to thank everyone who has reached out to support my efforts here. So many have asked how they can help. You can help by sharing this episode. In this way, you can help change the conversation about impaired driving in Canada. To honor Abby's life, you can help by choosing never to drive impaired, to speak up when you see someone about to drive impaired, and to call 911 whenever you see someone you suspect of driving impaired. Together, we can make the world a little safer for all of us. If you'd like to check out the references for this episode, you can find them in the description. I've also got them posted to the podcast website at www.lividpodcast.ca. There you can explore to find other episodes and learn more about me and Abby. You can also find the Livid podcast on Facebook, Instagram, YouTube, and in the streaming services where you have your other podcasts. With each follow, subscription, and like, the podcast has more potential to reach others through organic search. If you think the messages of LIVID can help change things on impaired driving in Canada, please take a minute to like, follow, subscribe, and share it with people you think might want to listen or join the conversation too. That will also make sure that you hear when the next episode is available, so you can find out what I've learned next. Thanks for listening.